happen to our estate, our kids, and how they should be taken care of, and how our wishes are carried out. Now, during our lifetime, we know we have all these assets and how these are managed and what kind of what do you call issues that can be there if we do not have the planning, and how do we how does this protect from what do you call legal aspects or liability aspects. That is one. Second, during our incapacity, think about it. Assuming we are not able to make any decisions, who will make decisions for us? By doing this advanced planning, doing estate planning, we are going to keep it in stone, keep it in writing, that these are my wishes and this is what we are going to what do you call, we need people to make decisions on behalf of us by following this direct. And after death, I'm not here anymore, but then how is my estate handled? When are my kids going to get hold of estate? Are they what do you call are they adults? If the are they minor children? And if so, who will take care of the minor children? And what if there are any special needs and all? So these are the different stages during which we do need to have a concrete plan so that our wishes are carried out. Now, life planning, we talked about incapacity planning, death planning. All these three components put together is estate planning. And estate planning means peace of mind. Without estate planning, there are lots of implications we will see during this 1 hour session. And we'll also have a Q&A session too. What happens if we fail to plan? That is a major thing. Most of the people, most of us are, okay, we know there's something called estate planning. We know we need to do it, but we have not done it. And we procrastinate it. It's okay, I know I need to do, but okay, I'll do it, I'll get to it. But without realizing there are serious consequences. What are they? Suppose we pass away without having a concrete estate plan. Then what will happen to our financial assets? Our bank accounts, they can be frozen, they will be frozen. Our medical benefits, whatever those benefits that we are not able to take decisions, that is impacted. Medicare benefits, medical benefits, they'll be impacted. And public benefits, Social Security, how it needs to come, who will be getting it. Real estate, we cannot sell it if we are not there and it is in litigation. So until that is resolved by the court-appointed judge in the probate, that cannot be. Same thing with business transactions. Because we are not there, nobody knows who is next authority in line to sign off on our behalf. Retirement accounts, all our 401k accounts and IRA accounts, all of them. Each one has a different way of handling it. And before that is handled before the decision is taken, court-appointed judge has to make a decision. These are the people who will get, and in case of minor children, this is what is going to happen. And all these things will happen in case we fail to plan. What about long-term care? All these things. So assuming we do not have any of this estate planning done, then court-appointed conservatorship, basically somebody is in charge of us, somebody will be taking care of us, even whether it is adults, if they are not able to, and for the kids, it's the same thing. So in order to avoid all these pitfalls, it is important that we complete this important aspect. Now, continuing, what happens if we don't do any planning? Now, who has the authority to make medical decisions? Is it our spouse? Is it our parents? Is it siblings? Depending on what age we are, right? I don't know how many of us can recall a person by name Terry Chivo. She was on ventilator for multiple months, or actually more than a couple of years, I think. She was totally bedridden. She was vegetable, basically, was on life support with ventilator. Now, husband stance was, I do not want to see my loved one being a vegetable in the bed without knowing anything, whatever is happening, just there's the life support. And I want to take it out and let her go peacefully. But the parents insisted, no, we don't know whether there will be a medical breakthroughs wherein she can come back in case there are medical breakthroughs. So the battle went to court, and for a long time it went on. Finally, I think husband did prevail. But in order to avoid all this ugly court battles, and also I don't want to be in the bed, I mean, as a vegetable on a ventilator, I better make a decision now when I can in my conscious brain and in a able, what do you call, state of mind. So that is why we need to have a complete estate planning in which advanced medical directive is one of the key components. Now, life-sustaining treatment, ventilator, or organ donations. For example, I may be passionate about donating my body or organs, then I better do it now in writing so that it will be carried out when I'm not there. Otherwise, people whoever gets in charge to make decisions as per their own belief system, as per their own will and wish, will be carrying it out. And including disposition of remains. Do you want to be buried? Do you want to be cremated? Do you want the ashes to be dispersed all over the world, or you don't care about it? All these things we need to, if we do not plan, somebody else will take care of. Somebody will get to make the decisions. Now, you have seen in the absence of having a complete will and, estate plan with the will and trust in place, the solution is conservatorship. What is conservatorship? Now, a conservatorship is a court case, basically wherein a court-appointed judge, a court judge, appoints a responsible person or an organization who is called a conservator to take care of another person, adult, or who is called a conservative, who cannot take care of himself or herself or manage his or her own finances. So these are wide implications. I may be medically incapacitated, so I need conservatorship, or I am all right physically, but I'm not able to make decisions in a sane manner, and I'm making a mess of my life. So somebody filed a case in the court, whether it's our parents or our caring spouse or our spouse, what do you call, siblings, then court can look into it and say, yes, you are not able to take care of yourself. So court is appointing this particular person as a conservator, and you got to follow. Some of the, what do you call, a lot of famous cases are there. Britney Spears was a few years back, ended up in the court conservatorship because of all the crazy things that she was doing. And people say, okay, who are the parents she's not taking care of or not able to take care of herself and kids and all. Now she's all out of it, good and doing well, that is different matter. So that is what is a conservatorship is. Now, what happens if we don't do anything else continued on that? Who will have our physical custody of our minor children? Who will be guardians of minor children's assets? And what about special needs children? What if minor children are beneficiaries of huge financial assets, so be it our life insurance policies or large financial, what do you call, retirement accounts or investment accounts? We need to know that these are a much serious issues that will happen if we do not do enough planning. Think about it. Your brother, your sister, your aunt, they may be living in the next street, next house, next city. But without we putting it in stone, in writing, that if something should go wrong to me and my wife, then these are the people, 1, 2, 3, are responsible to take care of my children. And they will be trustees to my trust. They will be guardians to my children. And they will be 1, 2, 3, these people will be the people who can make decisions, medical decisions, advance directive on behalf of me if I'm not able to take decisions. So unless you put it in writing, court will have to decide whether, even if your brother or sister is next door to you, whether they are the right people. They will see the history. They will see all kinds of, what do you call, proof. They will take, court will take its own time. The court appointed judge will take his own time. And there's a process wherein it, what do you call, they need to be certified. And during this process, the kids will have to be in a foster care. or your assets will be in a frozen state. It is in a what we already talked about as a probate. So to avoid that, we have to make decisions in advance. And once again, what is this is what we are calling about total estate planning, in which will and trust. Trust is a legal entity. Trust is a legal entity which will be holding all our assets, all our estate. And will is a directive. Basically, it is in writing what needs to happen, your wishes that you are writing in. So together, they dictate how your estate needs to be handled, your kids need to be, what happened, who will be taking care of it, and what will happen to you when you are not able to take medical decisions. Now, how does this, the whole thing get resolved in case we don't put this in writing, in case we do not have the will and trust in place? Then people who are close by, who are interested, will have to file a petition in the court saying, okay, this XYZ may be super close, he is maybe his own brother or sister, but they are mentally, physically, financially, emotionally, socially not capable of taking care of these children, and the children are in danger. I am a close family friend for last 15 years, and I know exactly the family situation. I am the person who can take care of it. So that's where the litigation, that's where people will have to file a petition for getting the guardianship and all. So to avoid all that, we need to have in place. Now, continuing on this, what else will happen? Assets are frozen, court battles are absolutely given a guarantee. What are the assets? Different assets, bank accounts, investment accounts, or real estate property all over the world. Businesses, if I own a business, whether it's corporation, I'm a major shareholder, or whether it is individual LLCs, those things. Retirement accounts, whether it is 401ks, think about it. If your children are adults, the 401k immediately vests and kids will get it, whether you like it or not, whether they are in position to take care of it or not. Same thing with your IRA. At least IRA, you have a little more control. It doesn't need to immediately vest, and you can actually specify that. Then your life insurance, how the money gets distributed to how many kids. Is it kids, or is it wife, or is it split? What are the different kinds of scenarios? All that will have to be addressed. Now, what is the solution in case of this? Small estate affidavit for assets lower than 166K. So assuming all total entire estate is less than 166K, a small estate affidavit is enough to get hold of it, to control of it. Otherwise, court-appointed judge will handle the entire process, and that is called your estate is in probate, right? Now, what's the problem? That's okay. There's a process, there's a legal process, government is going to take care of it. I trust the system, perfect. I don't need to worry about going through the hassles of doing all this. Here is a challenge for that. Here is the reason why we should do and avoid probate at any cost. All your entire assets, they go into the probate, and there are multiple people, systems, different layers who live on that, or basically there's a huge cost on that. Look at that on the picture, pictorially, all that. And then there are costs, probate costs, attorney costs, court costs, executor costs, income taxes, death taxes, appraiser costs, and CPA fees. All that, after that, what is coming is trickle of your asset to your kids over a period of time. How huge? The cost can be pretty high if it goes into the probate. For example, here, file a petition for probate. Estimated time, it can be 60 days, 30 to 60 days, and on an average about 435, one petition. If it is multiple times, it is multiple. Now, public notice of administration of probate, $500 cost. Then again, you have all other fees. So it all adds up. There is some more examples of this. Now we'll see those the cost one more time. Now, what happens if we do not do any planning and there's a default plan? Government has a default plan. I mean, what do you call? The law has defined that who gets the estate. What is the default plan, which is also called interstate succession? This is government plan. What is it? If a person is single and owns assets, automatically all the assets will go to parents. Sorry, this the what do you call the sequence is this: children first, children, and depending on the number of children, it will go in equal shares. If a person unmarried and do not have children, assets go to parents. If parents are not there, then parents issues, that is siblings. And if siblings are not there, then it goes up grandparents. And in equal shares again, wherever it is, it's all equal shares. Assuming grandparents are not there, then grandparents issues, that is aunts and uncles. That's where the estate will go. And then stepchildren, and then if there is nothing, it is state. The state will get after all this. So look at this. For example, I hate that long lost cousin or that aunt or uncle. I have only one absolutely mean character and devilish from the childhood. She tormented me. But guess what? If I did not take care of, and if she is the only one, she is going to get the entire asset, your entire estate. So that is where it is. This is the sequence of succession government plan. Now, what if one is married and in the community property, like in California community property, one is married and passes away, surviving spouse gets whatever the community property means, the property that is owned jointly. A separate property, no kids. If there are no kids, entire that comes to the surviving spouse. Okay. Now, what if there are kids? Then community property, the property that is jointly owned, is given to the wife or spouse, husband or wife, the surviving spouse. And then separate property, that is individual separate property, if there are kids, and then half is given to one kid, half is given to wife, and half is given to one kid, one child. What if there are more than one child, one kid? Then again, community property, which is jointly owned, automatically goes to the spouse. Separate property, which is owned in one's own person, that is he or she, 1/3 will go to the spouse, surviving spouse, and 2/3 will go to rest of the children in equal portions. Now, this is important to know how much of fees that is there, because it's going to be huge depending on what kind of estate we have. Now, what are the different statutory fees? This is only statutory fees. 4% of first 100,000 plus 3% of the next 100,000 plus 2% of next 800,000 plus 1% of next 9 million assets, and plus half a percentage of next $15 million is what the statutory fees itself. Simply doing some kind of a simple example, if there is a value of the property is $1 million, only statutory fees, I'm not including anything else in this, is coming to almost about 23,000. Why? Because we failed to do some important step, then it is going to the court, and statutory fees on a $1 million is $23,000. Now there are other costs. Say only a few of them are captured. So statutory fees is 23,000, personal representative statutory fees, attorney statutory fees is another 23,000, and any extraordinary fees, attorneys, they go by our hourly rate. And again, that is not cheap. It is very expensive. Any attorney worth his salt will charge up to $500 and above in fees. That's how they make their living. Filing fees $870, and publication fees $500, appraisal fees $1,000, estimated total is 48,370. And think about it. If there is a litigation between the kids or whoever, if this has to be disposed of and given money in pure cash, then there are other sales proceeds costs and all those costs involved with liquidation and all. So that will add up on that. So see how quickly the costs get added up. Now, one more, going back to like who will get and all. Prince, absolutely fabulous person, like huge fan following, left all those fans in absolutely, what do you call, real tears and all. He passed away in a lift, whatever the case is, overdose or otherwise. He left a $250 million estate without any will and trust in place. As a result, a huge litigation battle, including some waitress in some hotel to different, all those people are claiming filed right on his estate. Sister, 5 half siblings, and all of that. Current expenses paid till date, $45 million, of which $10 million is the legal fees. Think about it. That's a huge mistake. Now, what are the different estate planning tools? These are the different components. Will and trust. I mean, we need to have a trust, which we talked about it. There's a power of attorney, and there's a HIPAA guidelines, and life insurance component, health directive, will, which essentially describes what we need to, our wishes are and all. Now, this is important. Look what happens, who gets control and when in different scenarios, right? Estate planning documents and what applies when it does apply. Who controls when our health is good and well-being? If I am alive and healthy, I control it. And financial assets, I'm healthy, I control it. All those things. Financial assets held in trust, I control it as a trustee. I have a trust, established will and trust, I control it. I'm alive and healthy. Now, something happens and then incapacitated, right? Mentally and physically not able to make decisions. Who controls, your health and well-being? The agent that is identified, appointed under Advanced Healthcare Directive, or court-appointed conservative if there is no Advanced Healthcare Directive. That's where it's important. You specify who is going to take care of. What about your financial assets? Attorney, in fact, under the power of attorney, which you have specified when you are completing this estate planning, or court-appointed conservator in case if no power of attorney exists. And who controls financial assets held in trust? Successor trustee of the trust. You have already identified, and those people will be the trustees, will be handling all your assets. Now, I'm gone, then what happens? Who controls health and well-being? There's nothing. Agent under advanced directive. But who controls assets and financial assets not in trust? These assets are not held in trust. If there is a designated beneficiary, whoever that is, your kids, or you have decided whether it is a charitable organization or whoever that is, they get then the beneficiary. If no beneficiary designation is there, then to the executor under the will, probate, whatever, they will decide who needs to get. Then if the assets are held in trust, successor of the trustees of the trust, and they will have to act as per the will that you have specified. They have a legal obligation to carry out your wishes. That is why, once again, it's very important, because of all these consequences of huge costs that are there in case of litigation. We don't specify what should happen to our kids, ourselves, our estate. Now, we'll see a little bit of the process of it once we have it in place. The revocable trust that we establish, it is a life and death planning tool what we are having. Revocable trust is also called a living trust or inter vivos trust. What is it? It's a formal agreement by which grantor, that is a person who is, vests the legal ownership of assets to the trustee, that is the people whom he identified. Normally, I recommend you decide on 3 trustees, not one, because again, it's a question of what do you call uh, probabilities. One person, something can go wrong. 2 people, I don't recommend, because what if they disagree? 3 is the ideal number. Again, not too big a number, ideal number. So decide on 3 different people as a trustees. So once again, formal agreement by which the grantor vests the legal ownership of the assets to the trustees who are under legal obligation to manage those assets for the beneficiaries, and as per the wishes of the trustor, they give the assets in whatever the time frame, income wise or over a period of time frame, as and when that is what you call as decided, as requested, they need to hand over. During the lifetime, this is what is going to happen. This is what is a pictorial, like what you call representation. The trustee, the grantor, and the beneficiary, all of them, the assets are in the revocable trust, right? Anytime, if the grantor or the trustor, if he or she wants to change, they are most well, they can do anything they want to, because that's why it is called revocable trust. You can basically get rid of that, or you can add it, you can modify, you can do anything. As long as you are alive, you can do all that. That's why it's called a revocable trust. All your assets and estate are in that, right? Now, what happens during our incapacity? That is when the trustee comes into place and he is going to make decisions, take care of it. You are still alive. The assets are in the trust and the beneficiaries are there. And the trustee is going to make decisions based on the advance directive that is in place. Now, what happens once the person passes away, the trustor or the grantor passes away? That is when the trust becomes an irrevocable trust. The trust becomes an irrevocable because there is nobody to change, and the wishes are absolutely etched in stone, and that is what it is. The trustees will have to control and manage the assets of the estate and ensure that the wishes are carried as per the will, ensuring taking care of the beneficiaries and ensuring the benefits are passed on to the beneficiaries as per the what do you call wishes mentioned in the will. Now, advantages of trust, we already have seen what are the advantages, right? Basically, avoid probate, litigation, costs, huge costs, and time consuming. Think about it. Your entire estate is in the court, what do you call, and the kids are not able to get, what if there is, what do you call, children different from different marriages or otherwise fighting with each other, some of them in dire need of some real money to live their lives or medical needs, they can't get it because the entire estate is in probate. Avoid medical recovery by the government. Medical recovery is a huge deal in California. Medical is essentially California government is providing what do you call the medical coverage for the people. In the absence of trust, the government of California can come and get file for recovery or recover some of the costs that they have spent from the estate. Control the distributions to the minor. Again, when are the children going to get the estate? If in the absence of this, the moment they are 18, they get the whole. And how do you distribute? How do you ensure when to get? Is it when they're 18 or when they complete their undergrad? Or no, they're not yet mature enough. Maybe they after they are done with their graduation, and maybe after they're married, maybe after they have a kid. Or so you decide that depending on what it is. Then we need to enter this all this will and trust. Having a trust, the assets are essentially or located in the United States. What happens if my assets are in India or somewhere else? Each country has their own rules and regulations and laws in place on how they need to be handled. You will not be able to mix and have the different assets of in the same trust here, because the rules are different, and the each country has their own how the estate is vests, and what kind the sequence of beneficiaries. There are different things that are in place, so be careful about that. Now, a couple of legal medical recovery, I talked about it. As per the old law, this is what California Department of Healthcare Services can seek repayment of medical services from the property of the deceased medical recipient. So there's a medical recipient, they can seek the repayment from the estate. The rules allowed for the recovery from any assets owned by the descendant at the time of death, regardless of how those assets were titled or held. That's a key. Regardless of how those assets were titled or held. Department of Health and Healthcare Services, DHCS, could also seek repayment of medical services provided to a predeceased spouse. That is a spouse who predeceased. Now, that law changed in 2017, which says no recovery against non-probate property, joint tenancy property, and trust property. That's a huge deal. So if your property is in the trust, no recovery against that for medical payment. No repayment for medical services to a predeceased spouse. So this is how you can protect your estate, especially if you have minor children or otherwise, so that anything that is essentially medical, like you need to be qualified, but in case you get vested something else and comes into position, then the children are can get the benefit without a government recovery on that. Now, some of the exemptions. Now we'll look at what these estate taxes and how huge it was, and what are they now, and how they are in future. Do you know that estate taxes are 40% if your entire estate value is in these limits? Now, lifetime gift tax exemption in 2017 was 5.49 million per person, but Trump Job and Tax Cut Act of 2018 has ensured that that limit has gone up to 11.58 million per person, meaning in my entire lifetime, I can gift without taxation of 40% up to 11.58 million. And for couple, it is huge. That is $23 million. Same thing with estate tax exemption, which was $5.49 million, meaning if an individual's estate value is about anything above 5.49 million before 2017, and he or she passes away, the estate tax is 40% on the amount above that. So if you have a $25 million estate, $5 million and $15 million balance, 40%, about $6 million is the estate tax. Now the same is changed to, that limit is changed to $11.58 million. For couple, total comes to $23 million. That's a huge jump. But remember, these limits are going to automatically roll back to the previous limits in 2026, that is in 2026, all of Trump's tax cut benefits for individuals are going to roll back to the previous limits, including income tax and all these exemptions, unless Congress acts on that. So we'll see how it plays out. If Joe Biden is is expected to come, and he has already announced his plan and all. As per that plan, he has some certain provisions in place where some of these tax benefits are expected to be rolled back much before 2026. What does that mean? If you're planning to do something, do it before or put it in place before. So if just to take advantage. Now, non-resident ownership of US 60,000, that is H1Bs, for example, even today, it is 60,000. So just for the sake of discussion, if there is an H1B, a couple or a person, and they were fortunate enough to build huge assets, and tragedy happens, like the Yosemite couple, assuming they built about $5 million worth of estate, and they pass away, and nothing is in the estate, 60,000 is the benefit that is given to the non-residents, non-citizens. That means that $5 million minus 60,000 will be taxed at 40%. Annual exemption for the what do you call individual benefits, right now it's 15,000, tax rate is about 40%. Now these are the rates, estate tax rates over a period of time, and historical estate tax exemption and top estate tax rate. You see that this line, that is the tax rate. And what you may be wondering, why is it zero? Basically that 1 year they are given made it zero after the Great Recession of 2008 and all. And then it quickly came back up 40%. Right now the limit is about $11.5 million. That is per individual. Together it's $23 million. Now, when do you pay estate taxes? Estate taxes are payable within 9 months of the death. Death happens. Within 9 months, the estate taxes become payable. Now, here is a scenario of two different tax structures, what it is going to be. So in 2020, for example, today, your overall asset value is about $6 million. And basically you don't, because you get an exemption, you don't pay anything. Whereas in 2032, for example, the tax cuts have expired and the original previous limits apply. Almost on $12 million, you pay 40% of that. I mean, total taxable estate is about $2 million and 40% of it about $800. So 800,000, not 800. Okay, so that is a huge impact. People who are rich can afford to pay, and that is fine. That's a different debate. But essentially, we are talking about what is the estate tax right as of now. Now, California is introducing a bill called SB 378. Irrespective of what is happening at a federal level, California estate taxes, the bill proposes that the limit of the estate be reduced to 3.5 million, so that, and see, with the same tax rate of 40%. That is because California is a huge welfare state or is a good state, whatever. So this bill, if it is passed, essentially your tax exempt limit for your estate is pegged at 3.5 million per individual, which is about 7 million per couple. And the tax rate is at about 40%. So this is what proposed, 3.5 million at 40%. Federal at 11 million, and 2026 about 6 million. It goes back to if Congress does not act on it. Now, when a spouse dies, a portability, what is that? Take your deceased spouse unused exclusion amount you must make that election of the deceased on the deceased spouse timely filed estate tax return. Meaning what? If your spouse has certain exemption limit benefit and you afterwards your limit is exceeding, then you have to file a portability case in time, 9 months from the date of death, saying that so much of unclaimed benefit is there from my spouse. I want that to be credit to my account so that I get a much higher what do you call exemption limit. 9 months is the time. Now, how can we do the estate planning? There are different, what do you call, simple solutions costing absolutely nothing and a little bit more. Where online, there are multiple tools that are available. Okay. So, for example, cycla.org, zero cost, you can essentially put in place a will. You can have a power of attorney given. You can also even have a, what do you call, a health directive document. You can do it all online. And then there are third-party online websites which are anywhere from about $0 to about $400. Legacy Shield, for example, gives up to $400 charges. It will help us establish a trust and also will, power of attorney, health directive. Without trust, just to do the will, power of attorney and health directive costs about $100. But if you want to go to somebody and a knowledgeable, experienced, an attorney, so that it is not a cookie cutter just answering a sequence of questions, but yours is much more complicated. You have multiple assets, multiple different domains, regions, and your own, you have a complicated structure, or otherwise it is better to go to an attorney so that they you get the benefit of their domain knowledge and expertise. And that cost can be anywhere from $1,500 to $6,000. Most people charge around $2,000 to $2,500. And if you are an employee and if your benefit, if your employer has a benefit of legal fees, wherein you must be paying about $5 to $10 every pay cycle, then a lot of these attorneys do cover the, what do you call, do accept the benefit from your employer under the legal, what do you call, coverage. So that can be, for example, we know that for Oracle, they have coverage all the for about $2,500 or so. So each company is different. Check it out. Now, this is all beautiful. So I'll take care of estate planning, so I'm done. No, that is where we are having a series of lectures. Estate planning is one brick. It is one foundation. It's one of the entire, what do you call, comprehensive financial planning and education. So what are the other things, different things which we are going to talk about it? Estate planning, protection, life, health, long-term care, assets, all your assets, retirement. How much of retirement income do I need? Is there a gap in my retirement? What is the amount that is, what do you call, for my living expenses? What kind of taxes are there? When do I file for Social Security? Just based on that individual decision of Social Security when to file between couple, we had this expert come and talk to us. The difference is almost about $1 million based on when the person, the earliest filing to strategically delaying between the wife and husband. So we have a session scheduled in the next few weeks. Do remember to attend that. Again, when do I file for medical care, Medicare? And what is that Medicare? Is it covering everything or are there any gaps? Do you know that Medicare, by the way, covers only 80% and that to certain, and the gap, whether it's hospitalization, whether it's doctor charges or prescription charges, the gap you need to do with the gap insurance, and that today is costing about $700 per month. So how do you plan for it? How pay for it? And more interestingly, that Medicare in retirement does not pay for any hospitalization, long-term care more than 100 days. That long-term care is individual's responsibility, anything more than 100 days. So how do you pay for it? Not when the event happens, we are absolutely helpless. We need to plan now. So that is where this education is all about. Then what about college planning? One of the most important thing, what do you call, that keeps our what do you call families up, parents, is, am I going to afford the college education that my kid want to have? The best of the colleges, not a community college. In fact, I am a fan of community college to an extent. You go do a couple of years there and then go to a college, you are going to save huge. Again, those are the different strategies. But then if my kid wants to go to Stanford and can get to Stanford, how do I pay for? 300,000 is minimum now we are talking about. California UC system costs about 160,000 today. Long-term care, health expenses, college expenses are growing at about 6% cost. 6% inflation compared to a regular inflation of about 2.5%. And with all this cheap money that is being printed, about $4 trillion already pumped into the system. And right now, Republicans want about to bring in an additional stimulus of $1 trillion, whereas Democratic Party wants about $3 trillion. They're just printing. It's just a book entry, journal entry they are putting in, so-called, okay, the Federal Reserve's balance sheet goes up by another $6 trillion. What does that mean? That means the money is losing value. We have to protect. So when it is losing value, the costs go up. When the costs go up, how am I going to pay for it? That's actually, today it is increasing at about 6%. So there is a very, very important session next week, Thursday, same time about 8 o'clock. Sally Wu, she's amazing. She is a college planner, professional, gives not just from the point of how do you finance, but also from the point of how do you help your kid plan and get to the college the kid wants. Don't miss that session. And then we have a couple of sessions planned for tax, what do you call, saving. By the way, I forgot to mention there's one session for health care in retirement. That's also lined up. And investments, the returns and what kind of risks and all. So all these different sessions are lined up. We are today winding up the third session. Now, before we complete this, there is one important thing that I would like all of you to, what do you call, be aware of it. That is what is called a Secure Act. That is setting every community up for retirement enhancement. It's a beautiful acronym, Secure Act. Couple of very important items. Everybody should be what do you call, aware of it. There are lots of things, but the topmost two, read this. Inherited IRA's 10-year rule. Are you aware that before December 31st of 2019, the inherited IRAs of parents, that is parents pass away, there's a 10 million, 20 million, 5 million, whatever that is, inherited IRAs, the kids had their entire lifetime to tap into that inherited IRAs. Remember, and once again, entire lifetime they had to withdraw from the inherited IRAs. Starting from this year, January 1st onwards, the inherited IRA's time restriction is 10 years, meaning the kids have 10 years to withdraw the money and use the money, enjoy. So what is happening? IRS wants their cut, not entire lifetime of the next generation, but within 10 years of the person's passing away. What does that mean? If your kids are already doing very well, they're already in the top bracket of tax bracket, and they have inherited whatever hard work you've done and put in about 2, 3, 5, 10, whatever million, they start withdrawing it. Their tax is already high, so their tax rate will still go further up or max limit. So how do you avoid that? There's no easy way to avoid entirely, but by planning a little bit in advance, if your intention is to build a real good wealth and also transfer the wealth to the kids, start building that transfer, working on that transfer of wealth in advance instead of just funding your money or building huge in your own IRAs. Start building that in your kids' name so that they don't need to worry about paying taxes, anything on that. So that's what important. Then required minimum distribution. It's increased from 70 and a half to 72 years. Do you know that if we do not withdraw money, certain percentage after 70 and a half, then government can take 50% of it as a tax, IRS takes. So if you are mandated to withdraw 10,000, you don't withdraw 5,000 automatically is taken by IRS even without you knowing. Of course, they'll send you a bill and all, whatever. That required minimum distribution age limit is increased to 72 years in what do you call in the Secure Act. So those are the two main things. There are multiple other small different items, but these are the two things which most people will be impacted and should be aware of. Now, we are winding up. This is what basically to have a solid financial planning, fundamental requirement is awareness, knowledge, and asking questions and ensuring that those questions are answered. And what is the answer? Put in place an action plan to take care of those things. How do I save for my kids' college education? Attend the next week's seminar session. Am I on track for secure and safe and secure retirement? We need to ask. This is where it's very, very important to have this financial health check. Unfortunately, like most people do once in a year annual physicals, health physicals, because that's a benefit given by the employer. But a lot of people even don't do that, unfortunately, only to realize that there's something major happening. But when it comes to financials, not 1 year, not 2 years, not even 5 years, not even 10 years, because we are thinking that we are on autopilot. We are super busy with our kids, whatever we have to do and all. So we have a 401k. Oh, I'm contributing to my 401k account, and I have a primary home. I'm good. And if somebody is enterprising enough for a little bit, oh, I bought a rental property, so I'm good. What about all other areas which I talked about it? So that's where it's important to have annual physical, financial physicals as well. Am I saving enough? Is my 401k enough in my retirement? What is my requirement? Is there a gap? And how do I fill a gap? Or I'm going to have a lot of money, and I'm not worried about gap, but if there's a lot of money that is coming in or bill, how do I save on those huge taxes? Taxes are going to kill us. That take it from me. Right now, the debt clock is ticking at $26.5 trillion. A couple of months back, before COVID, that was at $22 trillion. That's how much it is within span of 2.5, 3 months time. It is expected to hit 28 to $30 trillion by the end of the year. Who is going to pay for it? On one hand, the tax rate has come down all the way to about 19 to 22%, and the internal debt is going up so high. How are we going to pay for it? Taxes are going to go high. Taxes are going to go up. We need to plan for it. What about long-term care? And what about my monthly income in retirement? So all these things, it's important we ask these questions and address these and come up with a comprehensive plan. That is where we can have a safe and secure retirement and build a great wealth that lasts for a long, long time. So with that, we come to the end of the session. This is what I am. I also offer for all the people who are attending this session today a complimentary personal financial strategy. Absolutely 2 hours, very, very in-depth session. Everybody, it's like as I said, financial physicals, wherein I show where you are, what is that you require to have a safe and secure retirement, and whether there's any gap and gap analysis, and how you need to, what do you call, fortify your plan. And absolutely no strings attached, no nothing, no sales pitch, no nothing. It's essentially helping you, giving you a comprehensive understanding of where you are standing, and if you continue the same trajectory what you are doing, where you will end up. Is it good enough place, or you want to be in a different place? That's what it's going to be. With that, I come to the end of today's what do you call this session, and I open up the forum for any Q&As. If you have any questions, please type in the question chat box, and then I will read out, and Lila Garu, you are going to read out, we can answer those questions. Okay, question answers, go or type in the chat box. Leela Prasad Garu, can you hear me?
Yes, I can hear you, and I'm waiting for the questions to come. But there is one question on the trustees. So you said that your recommendation would be 3 trustees, and trustees will develop your assets in the time when you are not in a state to manage your assets. So
Yes.
what is the control on the trustees? How do we ensure that trustees do not abuse my?
It's 9 o'clock.
Trustees do not misuse, you said?
Misuse or abuse my assets.
That's a very, very, what you call, valid concern and a beautiful concern. That is where it is very important to choose the people in absolutely with the due diligence. So it's not enough they're your what do you call friends for a few years. It's not enough they're just your siblings. You need to vet each person impassionately with both the spouses, to partners sitting together, and put down all, first and foremost, what are the personalities, do they match up, who do they have their care, what do you call, ability to care for others, are they ready for taking the additional responsibilities, and do they have the capabilities. For example, the person may be a real loving caring person, on planet earth, but he is not good with finances. He has a problem with the drinking, or he's a problem with gambling. It doesn't matter, just love and all. On the other hand, the person may be absolutely fantastic, but has absolutely cold heart and is not a caring person. You don't want either, right? And so we need to absolutely evaluate each individual person. After doing all that, those 3 people, you need to, shortlist at least 4 or 5 people, pre-frame them, and what do you call, and then ask the questions whether they would be able to take care of it, and tell them in advance, we are not decided, we are just thinking about it, and you came to our mind, and we just want to honestly discuss with you, and because you are our good friend for last X number of years, or because you are my brother, this is what we are thinking. I am not at made up mind, we are not at made up mind. We just want to before doing that, ask you whether you would be able to be a trustee and be a guardian for my kids. After that, you come back again, vet and do the process and finalize 3 people. After all this, 3 different people. That's why 3 people, not 1 person. So if all the 3 collude together and rob your estate, God forbid, nobody can help. But hopefully that is not the case. That's why 3 different individuals. And by law, they are bound to carry out the wishes of the store to the print, so that tomorrow if somebody does not, then they can be thrown in jail, or they can be, what do you call, court can take an action against. It is by law they are obligated to carry out. That is why it's trustee. They have to carry out the wishes of trustor. So if they cannot, then they can be criminally prosecuted. Any other questions?
So that's all.
Okay. Okay. Do I have any questions? Okay. Looks like I may have a comment here. Okay. Can we have non-US citizen as trustees? How many trustees that we can have? Any upper limit? There is no upper limit as far as I know, but you do not want it to be a, what do you call, a polling battle later on. The more number of people, the diverse their thought processes, the difficult it is going to be. That is why ideally it is 3. If you want to have more, you can go up to 5. There is no limitation, but that is, you don't want it to happen. As far as non-US citizen as trustees, the challenge, think about it, something goes wrong. The non-US citizen, how is he or she going to discharge the responsibilities? They need to be present here in the court of law or to take the positions. What if he is non-citizen and your kids are citizens, and how is he or she going to carry out? So technically they may be allowed, but for all practical purposes, it is recommended to have people who are living here, citizens, either green card holders or citizens.
Okay, on similar lines, I have another question here regarding non-US citizens. Limit is only 60K, right?
Yes.
Does having a trust help with income tax? Also, is it advisable to have trustees within the country?
Sorry, I didn't get the last portion of it.
So it's the same thing. I think you answered.
Yeah.
So
Yeah, basically.
Yeah.
Yes. So basically, the advice is simple. Ensure that people, whoever the trustees are going to discharge their responsibilities, that obviously requires they are accessible, they're within the location, and they're able to take care on the legally and proximity wise and all that. Okay, that's why they need to be within the country. The question about non-citizens, the limit is 60,000, and by having an estate in place that is protected right away from the estate tax, and you can define the benefit over a period of time to your, for example, this non-citizens H1B couples kids, I mean estate. They 6 months, 5 months back in Frisco, horrible, unfortunate accident event. An Indian couple passed away going to on the day of housewarming session, along with the adult friend. 3 people passed away within 1 mile radius, leaving 8-year-old kid. Assuming that hopefully they have done the put in place the trust and all, will and trust in place, estate planning. Assuming they have done that, if they have any significant wealth, the estate will control that, and over a period of time, without the impact to the kids, that will be distributed over a period of time as needed by the kid for her needs. So that's where it is very important to have it in place.
Does having trust help in income tax?
That is the whole idea, right? So there are different legal, one second. So income tax per se, when you say income tax, what exactly is the income tax you're saying? Estate planning, having a trust is essentially to control how the estate is managed and handed over to the kids and all. Income doesn't exist so it is not an income tool per se that you contribute something into the estate to avoid and all. Those are the separate, your 401ks, your IRAs, they're all regulated based on that. But by having them in this, added to that, you are essentially ensuring, for example, 401k vesting immediately. There's a huge tax that if it vests and all, or IRS, you need to liquidate and then you need to pay those taxes and all. You are going to avoid those tax consequences by having these assets in a trust so that they don't need to be liquidated, and you are essentially controlling the passage of them into the hands of your kids, so that there is no one immediate liquidation and paying a huge tax. I have a question here. Are we supposed to have a separate will and trust for self and spouse? Can we include spouse as one of the trustees? So the question is, are we supposed to have separate will and trust for self and spouse? Can we include spouse as one of the trustees? Now, California state is it's a community property. Basically, wife and husband are together owning almost from the time they are married, the community property part of it. So the will and trust will together have that. In addition to that, if a person is before that, they can have a separate trust. Yes, that is only yours, not your wife's or the spouse's. As long as So that is depending on one's individual situation. If the majority of the audience here, they have some particular socio-ethnic background and all, essentially all your assets are in one single trust, and your wife, both partners are the trustees of the same trust. As long as they are living is in the revocable trust, they are also the trustees, trustor and trustees. When they pass away or when they are incapacitated, that's when the other trustees come into place. So to answer the question, yes, you can have a separate trust, and yes, your wife can be part of the trust, or you don't want it, yeah, not necessary as the spouse. I hope I answered that question. If you need further clarification, please type in Madhu. I mean, Venu. Yes. Any other questions? Okay, I have some more.
So there are a couple of questions on the Zoom chat.
Yeah, I'm reading this. Okay, first one I did answer that, any upper limit and all. How do we keep track of lifetime gift tax exemption? Is each gift recorded in a yearly tax filing? Okay, that's a very beautiful question. Essentially, you are expected to declare it anything above 15,000 or even otherwise. And that is what over a period of time, because most of the people do not hit the ceiling limit of $11.5 million per individual during their lifetime. For 99% of the people, it doesn't come into effect. But if you are falling in that 1% or less than 0.5% people, you better keep a record of it, or your financial advisors and the companies will do. To answer simply, summarize, yes, we are expected to keep track of entire lifetime gifting. Can we transfer the real estate to kids when we are alive and still get lifetime gift tax exemption? Can we transfer the real estate to kids when we are alive and still get lifetime gift tax exemption? This is a little more complicated, and anyway, so I would refer this to your CPA.
Once the trust is formed and we have the trustees nominated, does trustees have the authority to withdraw themselves from the trust?
Yeah, like you are essentially mentioning, specifying, they can always say they are not capable or they're not interested. So it is in your own interest that you amend your revocable trust and add new trustees, removing the old ones. So that trust document is essentially in your hands. You need to do that.
So can that happen?
Yes, anytime, you can do it the next day, you can do it next week, next month, as long as you are in a stable, healthy condition. You can that's why it's called a revocable trust. You can make any number of changes.
Okay. So that's all the questions that I have from here.
Okay, I think we do not have anything here. So with that, I think we are giving back 15 minutes of time. Thanks again, everybody, for taking time to join us in this series of sessions. I hope you enjoyed. I enjoyed thoroughly, and it is one of my passionate topics, because the simple fact that by not doing this, it is a huge deal. Please do put it on your calendars. And if you need any good referral and all, I'm not a CPA, I'm not an attorney, but I have very, very, very good, people who can help you out with that. And I do not get any commission or kickback out of it. I'm just doing because that is what I'm doing. But if you want to do a personal financial strategy, please do take that. You have my contact info right in front of you There's some last minute chat coming up. I hope it is not a question. Yes, it is a question. Can we transfer the, okay, we already talked about it. No, I think, okay, questions here. Are we supposed to have separate one? Got it. Thank you. Okay. That's about it. So once again, thanks a lot. Hope to see you all next Thursday at 8 o'clock. Please, we will send out the flyer. Leela Prasad garu, is the flyer ready by any chance?
No, not yet.
Okay, so the class 4 is college planning by Sally Wu. As I said, she is amazing. Please mark your calendars and attend. It is going to be a very useful session, and I actually recommend any of your friends, your neighbors, or anybody who is interested in the college planning, not necessarily the kids who are in high school, but this college planning, as she says, starts when the kids are in the tummy, in the womb. So that is how huge it is going to be. Please mark your calendars and attend next Thursday, 8 o'clock. See you all. Thanks. Leela Prasad garu, it has been a pleasure. We'll continue this journey. Thank you.
Thank you very much. So, Azad, the YouTube channel, can you exit?
Okay, let me just
Can you give the control to me?
recording. Do you want to